for, Mr. Gill?
Yes, I created these.
Now, this shows the potential outcomes of the investment, correct?
Some of the outcomes, yes.
Now, my clients tell me that you showed them the spreadsheet and chart during the meeting. Is that your recollection?
I don't recall. I don't have any notes to confirm it. But I do remember reviewing this with most of my clients, so I would have reviewed it with your clients.
Okay, so your usual practice was to show the spreadsheet and chart to all of your clients when discussing this investment strategy?
Yes.
And did you discuss it with them, Mr. Gill?
Yes, that's the entire point. I can use this to show them how the investment works.
Now, this spreadsheet and chart only shows positive outcomes, correct?
Yes.
And it shows an increase in the value of investment with continuous monthly cash flow. Is that correct?
Yes.
So all of the clients that were following your advice were only shown a visual illustration that showed the upside of this investment?
Well, we would have discussed the downside of it.
That wasn't my question, Mr. Gill. I'll ask it a different way. You didn't show my clients any chart or illustration that showed the downside risk of this investment, did you? You only showed them the outcomes for a positive outcome.
No, it doesn't matter. We discussed the risks. Everybody knew this wasn't going to be a guaranteed investment.
Mr. Gill, I'm going to suggest to you that you made a choice. You chose to only show a positive projection for the investment income because you wanted your clients to follow your advice, not question it. Is that fair?
No, that's not fair at all.
What really isn't fair here, Mr. Gill, is you downplaying the risks of this investment and misleading very vulnerable clients about the general risks of leveraged investments and the specific risks here.
No, now you're just putting words in my mouth. That's not what happened.
Let's approach it this way, Mr. Gill. Did you ever show projections using a rate of return of less than 6%?
No.
Less than 5%?
No.
Did you ever show projections showing a negative rate of return?
No. I've already told you this. I did not.
And you knew that a negative rate of return was certainly a possibility, correct?
Yes.
And there was nothing preventing you from showing your clients what the practical dollars and cents impact of a negative rate of return was.
No, nothing preventing.
Thank you, Mr. Gill. I have no further questions.
There we go.
I didn't want to have some feedback. Can people still hear me? Is this mic still working? We're okay in the back? Okay. So that was a slightly different way we do things in examination discovery. In this scenario, Brett had a little bit of an advantage because she had some admissions made on, through this MFA proceeding. And the idea was that she wanted to get those admissions in the civil proceeding. We'll talk about it in a moment why that is. Typically, those questions would be much more broad. For example, okay, I see on this KYC form you've identified your client's risk as moderate to high. Is that correct? Yes. Well, what does a moderate to high investment mean to you'd lay the foundation? Okay, so what was it about my client that you suggested that you thought they could be put in those boxes? So there would be a very detailed process. You'd still get the information in a longer way. This way, the lawyer was able to shortcut some of those questions because I'd already made an admission, so she could just jump to the chase and make the assumptions without laying the necessary sound foundation. So, the admissions that Brett were looking for were trying to do three things. They wanted to underscore the importance of the KYC because that's going to be an important part of the evidence. You're going to say, I know my clients are supposed to be in these type of investments based on their risk profile. That's how important the KYC is. So she wanted to get admissions from me to show that the KYC is important. Okay, did you do rely on the KYC? Well, the loan people relied on the KYC, and I modified that. She needed those investments. She wanted to confirm, the client's reliance on me. Get from me that I said, oh yes, I expect my clients to rely on me. And why is that important? Because at the end of the day, we don't want to back off. Well, they were very sophisticated investors. I just gave them the general picture. They were allowed to make their own decision. She's already pinned it down to say, I expected my clients to rely on me. Oh, so you expect that, but when you're giving them their information, what are they doing? Well, you're giving information about a positive rate of return. and showing all things are rosy. So, if I'm going to expect my clients to rely on me, and I'm only giving them this information, can they really give you that informed consent? And she obviously wanted to highlight the inconsistencies between the form, the loan applications, and the client's actual situation. Now, this is an egregious, issue. This does not say, well, my client's on the borderline, maybe they're, maybe have no investment knowledge. I want to put them up in a slightly different category. This is, there's some clear misrepresentations and mistakes and errors, as we tried to classify them as. So you see that she had leading questions, and that was, you'll agree with me, right? This is what it says. Because getting me to say yes or no pins me down. And you can maybe see at the end of that demonstration where, the advisor's going to seize on something. Oh, so you show them graphs and charts. Oh, yes. So now you can see that, the advisor may be thinking, oh, this is awesome. I'm getting some positive things. Look, I'm showing her, like, you're telling me I don't take very much notes, but here, I've got a document that I showed to my client. So she takes me down that garden path. Oh, so you put this in the document. Yes. And you expect her to rely on it. Yes. And so you show them this document. Yes. And it's positive outcomes. Yes. Did you show them negative? And then you can see the penalty. Oh, no, I didn't show them that. But we discussed it. But did you show them something? So she takes me down a garden path showing how important I rely on these documents that I've created and how proud I am of them, and then gets the evidence at the end of the day that, oh, well, you could have shown them a much more holistic view of the investment and you didn't do it. And the sarcasm, the skepticism, and hostility is designed to test my evidence and to make sure, that I'm not just going to, am I going to be a formidable witness on the stand, and I've got to be more aggressive? Am I just saying things to agree? Am I timid? All those techniques, it's not just to get the answer, but to test the fortitude of the witness. So here's what happened at trial. The client applied for early judgment without a full trial. And the way they did it, as I said at the outset, is I don't need to go to a full trial. I don't need to go to a trial to determine that you, my clients, relied on you, that they filled out the KYC improperly, that you did all these things. I've already got these admissions. I don't need to waste the court's time to do a full trial. And our rules of civil procedure do allow that. If you can go to a summary judgment rather than have a full trial, if there's sufficient evidence on the record that a court's going to say, I can really only come to one conclusion, I don't need to go to a trial. So that was the process that they wanted to use. And the issue in this case was, did my prior admissions in the MFDA proceeding result in adverse civil findings? So if I enter into a settlement where I agree on wrongdoing, have I now simply lost a civil case? The civil case comes against me. So we know the settlement was a public record. The court said some of it can be used at trial, but I can't give you a decision on a summary basis now for a number of reasons. Well, yes, some admissions were in there, but did the admissions relate to these particular clients? When I admitted on the FDA, I admitted to a broad scope of things in terms of issues. Can I say, certainly just based on that public record, that these admissions related just to Gerry, or was it maybe to the other 25 clients? So it's unclear what I actually admitted to in the proceeding was respect to those clients, so some further evidence needed to be taken. And I also tried to argue that I'm not bound by the proceeding. Well, again, that's not true. Although the admissions may not result in an adverse civil liability finding, they are certainly relevant to a lawsuit, and if you made admissions and even things, they can be used in court. They may not be able to read them in, but certainly can form part of the record. So if you make an admission out of proceedings, it can come back to hurt you in the trial. Now, the settlement also did not address contributory negligence. So, can we say the client was negligent? Well, can we establish that they were sophisticated investors despite my mischaracterization of their investment knowledge, despite my mischaracterization of the actual assets they had? Could I say that they contributed? Because when they looked at the loan applications and they saw I put $80,000 for jewelry, did they sign off on that instead of saying, well, wait a minute, it's only 40? So some of those issues couldn't be decided or weren't addressed in the settlement. So we have to go to trial. We have to go to trial on that basis. So in the summary judgment motion, the court eventually said, listen, I'm going to leave the issues of whether or not how the admissions can be used in this proceeding to the trial judge. They appealed, they went up to the Court of Appeal. The Court of Appeal said, no way, agreed. The admissions are not exactly clear, but let's let the trial judge how to do it. So we did have to go to continue to a full trial. And the cost of arguing that motion to appeal was about $13,000, $14,000, so $8,000 were awarded to the advisor. So the case itself didn't really address whether or not I was liable. It's whether or not those MFDA settlement hearings can be used publicly or can be used against any civil proceeding, and they absolutely can. So I do want to throw it open to questions, but what I want you to think about is when we did that examination, we've always said when we do these things, it's important to take notes, right? Because you can see some questions. They're going to be say, well, how many clients do you have, sir? My total roster is 475 clients. Okay. Do you know how many financial investors, advisors my clients have? No. One. It's you. Oh, okay. So when we have a discussion on April 5th, 2017, who do you think is going to best remember the content of the conversation? You, who have 450 clients, or my client who only has one financial advisor? We always talk, that's why we have note-taking, and you can see the lack of note-taking here comes back. Well, I told my client that. My client says you didn't. Well, I did. Well, my client says you didn't. Well, do you have notes? I don't. But you admitted to the MFPA that you did not, that you made these mistakes. Yes. So now we've got some evidence. Well, I can't rebut that because I don't have any notes. You can see the importance. We always talk about the importance of giving your clients the full information so they can make that a sound investment choice. Well, does that make sense to simply give somebody the positive outcomes? I'm telling you, borrow money against your house. That way you can invest more money you got. The upside is fantastic. And if I'm going to put things in front of you that show, look at a rate of return at 6%, 7%. I'm just showing you rosy pictures. You're not really informing your client. And we can always talk about, well, you should give your client. And people say, well, I do. I talk to them all the time about downsides. But how do you do it? You can see how that situation where when you're talking about the upsides of the investment, you got pretty pictures and pretty charts that are showing, and then you say, but it can also not go well and only survive. You can't, and that's, I'm being somewhat facetious, but that's exactly what she was able to do through this cross-examination. She hammered me again and again. You showed them this picture. Yes, it was a positive. Did you show them less than 6%? No. Less than 5%? No. Less than 4%? No. Did you show them what would happen in a visual demonstration if things went below zero? No. Okay. But you do expect your clients to rely on you and follow your advice. Yes. So you get those admissions, and you can see how a closing argument would be at a trial saying, he's admitted that he expects his clients to listen to him. He admitted that when he gives them advice, he only gives them the positive side of things. He admitted that he made these mistakes on the KYC. You can see that those admissions, and when you got that, when you can put that together in a narrative, that the judge, it's going to be very difficult for the advisor to say, well, I didn't do anything wrong, my clients were fully informed and knew exactly what was going on because I detailed it. So we talk in the abstract about note-taking, the importance of being, full disclosure to your clients. Until you've been through this, you don't really realize how significant those can be. So we're probably not telling you any new things that you should be doing, but hopefully we'll be able to crystallize them and bring them down so you can see that they have to work in a real-world example. So that's the summary. Do you have any questions about what you've seen or how it works? Yes?
Just wonder what the plaintiffs asking for in this situation.
They were asking essentially to be hold in two parts. They wanted to make sure that they weren't responsible for the money they borrowed, so that $1.75 million they never would have been approved for, so they wanted it out of their money. They ended up losing about $650,000, so they wanted the full amount to be hold. I don't believe they were asking for loss of opportunity, so I gave us otherwise, but certainly to be made whole. And I don't believe it actually ended up running trial, but I don't know how the settlement ended.
So, sending a summary of that interview with the clients would be part of your notes. I guess that would be a key thing. Since people forget,
Yes.
Clients forget.
Absolutely. And that's a great contemporaneous record. It's a pleasure meeting you today. As we discussed, we did A, B, and C. Here's what I want to do. Here's a copy of the documentation I showed you. Please feel free to read it over again and let me know. Anything you can do to pull up the bill and say, look, it's not just I said, she said, I've got a note indicating I said that for sure.
And second question there, what's the dealership responsibility?
Well, the dealership responsibility is going to depend a little bit on the relationship, but if the dealership was authorized, I've had situations where the dealer itself can be liable because leveraged loans, oftentimes if you're recommending a leveraged investment, it needs to be approved by head office. So in that case, we'd say, well, if we're liable, some works a little bit differently in the insurance context. Sometimes we have programs where we defend the advisor, but we don't defend the dealer. There's a disconnect there. In that case, the dealer could face exposure because it's vicarious liability for the advisor, but in terms of their own independent act of negligence. If you've got a situation where the advisor says, I can't actually recommend the leverage documents until it's signed off on by head office. Now, in this case, I would suspect that